Good morning, or afternoon, what am I saying? Welcome to episode 49 of 5 Reasons Not to Harm Your Loved Ones During Quarantine. Just having a little difficulty with my phone today, so there we go. Today we are going to talk about personal protection orders, otherwise known as PPOs. We're going to talk about what they are, who can get them, who can be restrained by them, the difference between a personal protection order and a no contact order, what types of behavior can be restrained, and how you get one, how someone would object to one, or modify it or terminate it, or how someone would enforce it, and then what happens if you violate it. So that's where we're going today. Before we go there, some numbers for you. The COVID-19 cases in Michigan are now 63,169, and there have been 5,837 deaths. With the exception of Monday, I believe, the death rate has been about 25 to 50 range each day, which is certainly much better than what we were having before, which was hundreds per day. So we're getting somewhere here, and staying home is working. So speaking of COVID-19, the basically personal protection orders expire in a year, and in response to the COVID-19 pandemic, the Michigan Supreme Court entered an executive order, it's 2020-63, which suspended all of the expiration dates on PPOs if they would have expired during the stay-at-home order. So people did not miss out on their opportunity to be protected. Basically, what a personal protection order is generally is it's considered an injunctive order because it stops conduct. Instead of ordering someone to do something, it orders people not to do things. It's handled in the Family Division of the Circuit Court, and it can restrain or enjoin activity and individuals, as listed in the statute, or conduct prohibited under certain statutes, which are basically the stalking, the harassment, physical altercation, assault and battery, those kinds of things. And that in most cases, PPOs are issued against adults, but they can be issued against minors also. If it's a PPO involving a minor, the juvenile code will control, not the penal code. So that's the only difference. And the cutoff for being a minor in regards to PPO is, let me just make sure that I'm right. Yes. You have to be less than 18, so 17 or younger, and you would fall in the minor category. Proceedings to enforce a PPO that is against a minor after the minor turns 18 would then be held in adult court. So just because you start in juvenile court, certainly if you have your birthday and you turn 18, then you're going to be in adult court and held to the adult responsibilities. There's different rules if you are an immigrant or not a U.S. citizen. I'm not going to go through those right now in the interest of time, but certainly people should just be aware of that. Basically, there's 3 kinds of PPOs. I'll tell you that the third kind I have never seen in 26 years of practice. The first kind is a PPO that is based on a domestic relationship, and that is to restrain behavior, including stalking, that interferes with a person's personal liberty or causes them reasonable apprehension of violence if the respondent is involved in certain domestic relationships with the petitioner. So the respondent is the party that is being told stop doing this, and the petitioner is the person asking the court to tell the person to stop doing this. So, the second kind of PPO is the non-domestic stalking PPO, and that is to enjoin a person from behavior regardless of the relationship. And so the relationships that fall under the domestic are the petitioner is the spouse or former spouse. They're a person, the respondent is a person with whom the petitioner has a child in common, or they reside in the same household, or they have had a dating relationship at some point. A domestic relationship PPO cannot be issued if the petitioner and the respondent have a parent-child relationship and the child is an unemancipated minor. So what that means is the child has basically said, you're not going to be my parents anymore. A parent can't go file a PPO to keep them away, is what that means. And you cannot issue a PPO against a minor under 10 years old. That's the only other caveat. The conduct that's subject to restraint is entering onto the premises, so they can't come to the home of the petitioner. It can also be the person can be restrained from coming to the place of employment or coming to any property interest that person, the petitioner, might have. They will be restrained from assaulting, attacking, beating, molesting, or wounding the person, the petitioner. They'll be restrained from threatening to kill or physically injuring a named person. They will not be able to remove a minor child from the individual having legal custody, except if there's a custody or parenting time order in place. So a lot of cases where the parents aren't married and the parents get in an argument and there's no court order as to custody or parenting time, the respondent has nothing to stand on to go and have parenting time with that child. So it's critical, especially if the parents are not married, if you fear that there may be a complaint or an allegation, true or false, you have to have asserted your parental rights before it's issued, or you won't have any. This is the quick tangent. You have to either have filed an affidavit of parentage, your name has to be on the birth certificate, you have to have filed a case for an order of affiliation, or you have to have an open front of the court case acknowledging you as the father. Those are basically the 4 ways that you have, stuck your feet in the sand firmly to say, I'm the parent. Other conduct that can be restrained is if the petitioner is a minor who's been the victim of sexual assault by the respondent, and if the petitioner is enrolled in a public or non-public school that operates any of the grades K through 12, then the respondent can be restrained from coming into that school to go to any activity. If it's 2 kids who are involved, then this obviously doesn't apply, but measures will be taken to keep them separated. You can also be restrained from having access to records of a child, or restrained from having any conduct that has the intent to cause mental distress or control over the petitioner. One way that we see that is when one of the people involved takes the dog. That is certainly a way to exercise control. If you Also, there's injuring, killing, torturing, neglecting, or threatening to injure, kill, torture, or neglect an animal. Then that conduct can also be enjoined or restrained. The court has authority to include children and animals in a domestic PPO. The standard for which a domestic PPO is issued is it can be issued by testimony, it can be issued by documents or affidavits or other evidence in support of the request. It could be photographs, it could be medical records, it could be police report, it could be any of that. And secondly, whether the person who's to be restrained has previously committed or threatened to commit one or more of those acts that I just read to you. A court can refuse to issue a domestic PPO solely on the basis of no report or other indications of abuse. They shall not refuse to issue a domestic PPO solely because it's missing a police report or a medical report or a physical sign of abuse or violence. So it certainly can go against you for not having them, but it cannot be that it can't be the sole reason that it's not granted. I have a question. I love questions. Thank you. Why, when you have a personal protection order and you're going through a divorce and your minor child is named on that PPO, hold on, it cut off. I don't know if I can get the rest of the question. Hold on, I'm gonna pick this up, and I am doing this on my phone today, not on my computer, so it's a little more confusing. Okay, so if the child is in the PPO the first time he takes her because they say he has to take her, and then when they're told that he violated it, they do nothing about it. A protection order or not. I think what you're asking me is how come if a child is named in the PPO and a parent who's restrained from harming the child enforces their parenting time through a custody or parenting time order, how come that's not seen as a violation of the PPO? Because there is an underlying philosophy that a child has a right to have a mom and a dad. And if the restrained party can behave appropriately, then they should be able to see their child if there's a court order that gives them permission to see the child. When you apply for a PPO, there's a question on the application on whether or not there is an existing custody case or an existing parenting time case, and what the order says, and you're supposed to include the order, the case number, the judge on the application for the PPO itself. If the circumstances are such that a child would be in danger being in the presence of the other parent, certainly the PPO can override the circuit court custody order or parenting time order, or put restrictions or limitations on it. No overnights, supervised only, supervised at an agency only. It just really depends on the facts and circumstances of each individual case. So that's just issuing a PPO where the other side gets notice and it's not emergent. There is standards for issuing a domestic relationship PPO without notice to the other side, and that's called an ex parte PPO. It's one-sided, and in that instance, the court has to determine that there's reasonable cause to believe that the individual to be restrained or enjoined may commit one or more of the acts that we already talked about. And it clearly appears from, and this is the critical word, specific facts shown by a verified complaint, written motion, or affidavit that immediate or irreparable injury, loss, or damage will result from the delay required to effectuate notice, or that the notice will itself precipitate adverse action before a PPO could be issued in the regular course of business. So what is an example of that? Ex parte PPOs are granted if there is an alleged sexual assault, there's a criminal investigation, and we don't know how long that's going to take for the investigation to conclude. Then that would be a circumstance where someone might be in danger during the pendency of the investigation. Another one would be the boyfriend and the girlfriend break up, and the one or the other sends a million texts to the other one begging them to come back and threatens them with harm if they don't. Or if they have sent nude pictures to each other and one of them releases them on the internet as a way of retaliation. If someone, sends things to the other person's employer that puts their job at risk, or if they show up at their work constantly or call them constantly. So it's all kinds of things like that that can be determined to be grounds, fact by fact basis, for an ex parte PPO. PPOs are not valid until they are served. What that means is that they're not valid until the person knows that it exists. So sometimes what will happen is, let's say that a person gets a PPO in the morning. That afternoon, the person hasn't been served yet, and the person shows up at their house with a gun. When the police come, the person who is the petitioner can hand the police the PPO, and they will serve the respondent right there and then they can arrest him for violating it because it is such a dangerous situation. So that is basically what happens with PPOs in the domestic setting. In the non-domestic setting, they're called non-domestic stalking PPOs. And we talked about during the domestic violence segments what stalking is, but just to remind you, it's when a person, it can be regular stalking or cyber stalking, and it is basically when a person says, no, I don't want you to do that. I don't want you near me. I don't want you to call me. I don't want you to send me flowers. I don't want you to email me. I don't want you to text me. I don't want you to messenger me, kick me, whatever. And the person does it anyway. In order for it to be restrained, you have to have, in the non-domestic situation, you have to have more than one time when you have said no and the person has continued the conduct. And again, the girlfriend falls in the domestic, the girlfriend's mother does not. So there would have to be 2 instances of conduct in order for that sort of stalking PPO to be issued. They can also be issued ex parte, and again, there has to be an imminent danger to the person if they don't get it right away at that moment. Conduct that's subject to restraint in the for a stalking PPO is that they can't come within the petitioner's site, they can't come to their work or to their residence, they can't approach or confront the petitioner in a public place or on private property. They can't enter onto the property where that petitioner owns, leases, or occupies. They can't send them mail or email communications. They can't contact them by phone. They can't place an object on or deliver an object to the property that the petitioner owns, leases, or occupies. And they can't purchase or possess a firearm. and actually anyone who has a PPO against them, it cannot purchase or own a firearm. And in most cases, they're required to turn them into the police department for safekeeping during the pendency of the PPO's existence. Aggravated stalking is another offense underneath this that can cause a PPO to be issued, and that is when someone is on bond or someone's on probation for the same behavior that is now being enjoined by the PPO. If they're on parole, any of those sort of heightened levels of supervision, and they still violate it and terrorize or frighten or intimidate the petitioner. The standard, as I mentioned, between issuing a regular PPO or an ex parte PPO is the urgency of substantial harm. The third kind of PPO is a sexual assault PPO, and like I said, in 26 years of practice, I have never ever seen something called a sexual assault PPO. Of course, that's behavior that can be enjoined or restrained in either one of the other kinds of PPOs, but I've never seen it just on its own. So with that, let's talk about how you get a PPO. Well, there's a packet of information, and you can either download the packet that you get on the circuit court website. You can get a PPO in any county in Michigan. You don't have to specifically get it where you live. It has very wide jurisdiction in order to allow people to be protected no matter where they are. It's probably the only legal proceeding that has such a wide arm of protection and allowable action in the legal world. So you can either download the packet, or you can go, most circuit courts have a PPO office, and they give you the packets, or you give them the information and they fill out the packet for you. At that point, it would be, after it's filled out and any supporting documentation is provided, then it would be given to the judge's clerk. If you have a pending divorce action or custody action or paternity action or child protection proceeding, most courts in Michigan use the one judge, one family rule, so it's going to go to that same judge. And the judge will look at it and decide if this is a situation where there's imminent danger, and if there is, it could be granted ex parte. If it isn't, one of two things can happen. They can set it for a hearing where you would have to come in and show that you're in danger, and then it could be issued, or it could just be flat out denied, like you don't have enough. If it is flat out denied, you can certainly refile with additional information, but sometimes, the filing denied petitions are petitions where, someone caused harm 8 years ago and they've been in prison for 7 years and they're getting out of prison, and so they're afraid because this person's getting out. And that would not be granted unless there was a course of conduct that was harassing or stalking or assaultive or intimidating while the person was in custody, because it's just too long, it's too remote in time, and the person who you would be trying to restrain or enjoin may not even know where you live. So those are usually not granted. Those can be denied. After the 1 year expiration of a PPO, the court, upon request by the petitioner, if there's a showing that there's still danger, can have it extended for 6 months or for another year. And that extension happens on the paper. It's not necessarily a hearing. It could be a hearing, but usually it's just extended on the paper. Another thing, what has to go in a petition for a PPO? It obviously has to be in writing. It has to state with particularity the facts on which it's based. It has to have dates and times and conduct. It can't just say, he's mean to me, or, she threw a bottle at me. It has to say that it happened, yesterday. And then you also have to include, if you were injured. You have to include if there is, an imminent situation where you need it granted right away, as opposed to having a hearing. And if the two people who are involved, you cannot have mutual PPOs. You can't have one against Joe and Joe has one against you. That is not allowed. We already talked about existing custody and parenting time orders, and except when situations where it's specifically ordered in the PPO, those orders must be enforced and complied with. If the PPO is denied, flat out, as I just explained, kind of the circumstance that usually happens in. But if the court denies it, the court must state in writing the specific reasons for refusing to issue an ex parte order and advise the petitioner of a right to request a hearing. So if it's denied and the petitioner thinks that it should have been granted, they can ask for the hearing for it to be set. Sometimes they're just set for hearing automatically. So the petition, if the petition doesn't request an ex parte order, or if the court refuses to grant it, then the ex parte order, then the petition will be set for hearing. It's just like any other evidentiary hearing. There's witnesses, there's exhibits, documents admitted. The petitioner testifies, is subject to cross-examination, and then, depending on what the evidence or the story is, the respondent may or may not testify. If you are not represented by an attorney, you are still held to the rules attorneys are held to maintain the decorum of the courtroom, to treat the judge with deference and respect, to know the rules of evidence and the procedures that are incumbent in being part of a legal proceeding. So, a lot of people say, well, what do I need a lawyer for? I didn't do anything. And then they get there and they don't know what the burden of proof is, or what evidence would be the most important to get rid of it, and one of the things the respondent can ask for within 21 days of service, they can ask for the PPO to be completely terminated. They can ask for it to be modified, or they can ask for it to be amended. And in those circumstances, there would be a hearing, and that's where those proofs would come in. And then the respondent usually would ask for it to be terminated, unless there was a pending criminal case. Then it's not going to be terminated. So you're better off in that instance to present evidence to modify it. Maybe you're modifying it so that you can have supervised parenting time with your kids, or you're modifying it to be able to go out of state to see your sick relative, or attend a happy occasion, a wedding, or something. But that's really important. If a petitioner doesn't attend the hearing, it is dismissed, and it can not usually rescheduled, and they usually cannot get it back. So the next, we just actually talked about modification. As I mentioned, this has time limits. Actually, for a modification or termination, it's 14 days after being served when you have to file, and then they try to do the hearing very quickly. I think I may have said 21, but it'll be at least 21 days till the hearing, because you have to file it within 14, and then there's 7 days notice to the petitioner that you're requesting for it to be modified or terminated. So the hearing will be held usually in 21 days or more, but you must file and request that within 14 days of being served. The Michigan court rules do not state what the burden of proof is in a termination or a modification of a PPO hearing. So for the most part, the court has wide discretion on whether or not the person is in imminent danger, in danger, or someone else close to them is in danger. Ordinarily, there would be a $20 motion fee that would be charged to file the modification motion or request, or termination motion or request, and that is waived in all PPO cases. We talked about extension. And so finally, just a couple points. People think that PPOs are not really that big of a deal when they're going to get them. They're a huge deal. If someone has a PPO against them and they get pulled over for any reason and their driving record is pulled up, it will say right on the top of their driving record that there is an active PPO. It comes up on what's called the LEAN, the Law Enforcement Information Network. They may be precluded from enrolling in certain programs. They absolutely positively cannot carry a firearm, cannot get a CCW permit, and if they violate, if a PPO is violated, the penalties can be anything from, fines to restitution to jail time. So there's some pretty strict consequences of violating a PPO. You could also, it's grounds to be charged criminally with aggravated stalking if you violate a PPO more than 2 times. So that is another issue. That is a felony. And it could, I believe it's a 4-year max, that it may be a 5-year max. I'm just not remembering off the top of my head right now. So sorry about that. And so, that is pretty much what personal protection orders are, what they do. They're different from a no contact provision in a bond, as a bond condition in a criminal case, because the bond condition lasts as long as the case lasts, where a PPO has a start and an end unless you take affirmative steps to renew it. So sometimes there's both, sometimes there's one, sometimes there's the other. A lot of times if a no contact order is about to expire because the case is over, people will go get a PPO. But unless there's that danger, and the person has not complied with the order while it was in place, it's going to be really hard to get a PPO. For the most part, PPOs are a really easy mechanism for people to use to manipulate and shift the momentum of their divorce case or a child abuse case or child protection proceeding, because you just have to fill out, you have to make the allegations. If there's serious enough and the imminent harm or the imminent threat is viable enough, a person's going to get it. And so it is a very easy accusation to make and a really easy tool to obtain if you say the right things. So it's taken advantage of in many circumstances. Courts have been more skeptical, I would say, in the last 10 years than they were when all of the personal protection order mechanisms were first put in place, but it still is used in ways to harm other people or to get an advantage over another person in different circumstances. It is the non-domestics can be a Hatfield and a McCoy situation. The leaves from your tree are falling on my side of the fence. I pick them up, I put them back on your side, and you throw them back on my side. Would you necessarily get it for that now? Depends who the judge is. Depends what jurisdiction you're in. But so they are very, very strong tools of protection. Do they always work? No, unfortunately. But certainly they're out there for people who need them and who need to be protected by more than just telling a person, don't come near me, don't call me, don't text me, don't email me. If there is a pending divorce case, custody case, paternity case, child protection case, the PPO will control, with the exception of the parenting time order that exists, unless the PPO specifically addresses it. And so it's, like I said, it's a very, very, very powerful court order. Someone can be held in contempt. They can go to jail. And so it needs to be taken seriously. I have a lot of people who, call me and they're like, oh, so-and-so got a PPO on me like 6 months ago. Can you help me? And at that point, there's really very little I can do to try to terminate it. And we have to show special circumstances in order to modify it. So, it's pretty hefty. So with that, I will conclude for today. Next week, we are going to talk about divorce proceedings, separation, annulment, all that kind of stuff. And if anyone wants a little refresher, I believe it was episode 24 was the checklist. If you're thinking about engaging in any of those battles or untying of the knot or relationship in the future, you can listen to that. It's just tons of information, checklist type information about things you can do to be prepared and to help your lawyer and to minimize the cost. So that was episode 24, 5 Reasons, and it's on both YouTube. It has a different number on YouTube, though. The person who loaded them thought that he was doing a favor by separating them by who spoke to you on a particular day. So the numbers aren't the same, but I believe it's the gray sweatshirt, blue and white scarf day. If you're going after it on YouTube. Otherwise, it's episode 24 on the Kirsch Daskas Facebook page. With that, I will leave you with the 5 reasons not to harm your loved ones while in quarantine. Of course, number 1 is protective services are essential workers. Number 2 is that the police are essential workers. Number 3, that our jails and prisons are a hotbed for COVID-19. Number 4, parents can get in trouble for kids being kids. And number 5, of course, no one, if at all, very few people look good in horizontal stripes. So with that, I hope that you all have a wonderful weekend. Be safe, be healthy, find your happy, enjoy. Thank you, Brenda, for wishing me a nice weekend. I appreciate it. And I will see you all on Monday. Bye.